Can the surrogates court adjudicate a trust issue that's currently pending before another Supreme Court in the state of New York? To find out, you have to read Matter of Wagner, but it's 5 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. But this is part of a special limited series I'm covering on cases relevant to the elder law and estate planning community. This is a recent case out of the Surrogates Court of Suffolk County. The case is Matter of Wagner under index number 1181 of 2023. The issue in this case is whether the Surrogates Court can adjudicate the ownership of a trust and the assets of a trust when there's a currently pending matrimonial case in Supreme Court in New York County about the same issue. The background law that I think is helpful to understand this case is that CPLR, Civil Practice Law and Rules 3211, A4, talks about grounds, or A talks about grounds for motions to dismiss. And A4 says that a motion to dismiss can be made if there's another action pending between the same parties for the same cause of action in a court of any state of the United States, and the court need not dismiss based on this, but may make some other kind of order as justice requires. So it's discretionary whether it's dismissal. There's other opportunities, there's other options, perhaps adding a different party or adding other kinds of relief or transferring the case. But 3211A4 authorizes a dismissal if there's another case pending where there could be inconsistent results between Court 1 and Court 2. The other thing you have to understand to appreciate this case is that New York State has different kinds of courts. And there are courts of limited jurisdiction, think small claims court, which only has up to a certain amount of money, civil court, which only has a certain amount of money. There's surrogates court, which only has jurisdiction over proceedings relating to the affairs of decedents, probate of wills, administration of estates, ancillary proceedings, disputed claims, discovery proceedings, SCAPA 17A of guardianships, compromise and settlements of wrongful death actions. There's certain things that surrogates court has authority over. And then there's something called Supreme Court. And Supreme Court can hear basically anything. They can hear anything, including the things the other courts can hear. So Supreme Court can hear a matrimonial action, a case that would otherwise fall into civil court, otherwise fall into small claims court, criminal cases. They can hear anything. It's a court of general jurisdiction, not limited jurisdiction. The only thing they can hear is cases that are against New York State, which has to go to the New York Court of Claims. Okay, so what are the facts of this case? The facts are that Leon Wagner created 2 different trusts, the 2011 trust and the 2012 trust, and they have different things. 2011 is an irrevocable trust where all of the contents, all the assets of the trust are going to Leon's kids. That's 2011. But in 2012, he created a trust, him and his spouse, or him and his partner. And that was a conditional trust. That trust said, one of the conditions of the trust said that it would terminate if Leon and his partner cease being in a committed relationship and if his partner commenced illegal action against him claiming additional property rights based on their relationship. In which case, all the assets would be pulled out of the 2012 trust and go into the 2011 trust. That's the playing field we have here. So then what had happened? After the creation of these trusts, Leon and his partner are engaged in a matrimonial action in Supreme Court, New York County. Supreme Court, keep that in mind, Supreme Court, New York County. In that case, the partner is seeking a declaration that the contents, the assets of the 2012 trust, are her separate property. So Leon's son, Harry, goes to Surrogates Court, Suffolk County, and files this ancillary proceeding saying, hey, wait a second, the assets in that 2012 trust are ours because they should be going in the 2011 trust to which we are the beneficiaries. Because those 2 conditions that we talked about were met. Leon's partner, his spouse, in which he's engaged in matrimonial litigation, moved to dismiss under CPLR 3211A4. She's saying, hey, there's a case currently pending in Supreme Court of New York County that relates to the same or similar subject matter. This is grounds to dismiss this action. So what does Surrogate Messina do with this kind of a motion in this kind of a case? He has the opportunity under 3211A4 to craft alternate relief, maybe adding a party, considering alternatives. But remember, it's discretionary only if he can do that. But there's 2 different kinds of courts. Surrogates court is a court of limited jurisdiction. Supreme Court is a court of general jurisdiction. Supreme Court can hear anything. Circuit Court can't hear everything. So under those conditions, with these set of facts, the holding of this case is that dismissal is appropriate because you wouldn't want inconsistent results, inconsistent orders, where the Circuit Court says this is the rights of the parties and Supreme Court says this is the rights of the parties and they're contradictory. But also, the Supreme Court has general jurisdiction, can hear everything. They can hear this ancillary kind of application as well as the matrimonial. And so the answer is dismissal is granted under 3211A4. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.